Hi, this is Attorney Mike Gravel coming to you from Chicago as usual, and today we're going to take a look at the sovereign citizens yet again in Sovereign Citizens Court Fail number 4. This one even has a fez. Let's do it.
Cheyenne M. Cushing-Urell, would you state your name for the record, please? Your attributes for the record, please.
Cheyenne M. Cushing-Urell on behalf of the non-British Empire Aboriginal Law.
Oh, we start with a bang. No, you're not appearing on behalf of the Marrakesh Empire. You're the defendant. You're appearing on behalf of yourself. The judge, you'll see, is just too lenient with this whole situation. And don't forget to hit like and subscribe, or the dogs get it.
I want to ask you a couple of questions, please. The first question I want to ask you is, are you employed?
Objection, man. This hearing is supposed to be about jurisdiction. This court has no jurisdiction. The court has no jurisdiction to determine its own jurisdiction for a basic issue in any case before a tribunal.
Well, if I have no jurisdiction to determine my own jurisdiction, how are you going to get that issue resolved?
Listen.
Okay, I'm going to get this out of the way right up front. He's already in contempt. I would have him in cuffs already. It is completely inappropriate what he just did. First of all, he tries to appear on behalf of someone else, which is insane. Second, he objects to the judge and tells her she doesn't have jurisdiction, which she clearly does, but even if he wants to contest that, he needs to bring a motion. He doesn't know that, but that's okay. You just overruled and no. And then, and then he tells the judge, listen. This is completely outrageous and out of bounds. If I did that in Cook County tomorrow, I would have cuffs on me in 10 seconds.
This case in this courtroom is a colorable, incompetent court of jurisdiction. You can't, according to federal case law, you can't set another hearing to reach and determine your own jurisdiction. As I've stated for the record plenty of times, I'm only here to threat domestic coercion, and because the prosecution falsely holds my property, and I'm here to clarify that matter. Other than that, I'm here to threat the rest of coercion. It is completely against federal case law. It has power to act, and the court must have the authority to decide that question in the first instance. That's Rescue Army versus Municipal Court of Los Angeles. A departure by a court from the recognized and established requirements of law, however close apparent adherence to mere form and method of procedure, which has the effect of depriving one of a constitutional right, is an excess of jurisdiction. You have the flag right behind you, ma'am.
May I interrupt you for a moment?
No, you may not, ma'am.
Are you kidding me? May I interrupt you? Wow. And then he says no. She's just lost control of her courtroom. I like her. She's a smart judge, but she does not know how to control a courtroom. This is completely out of line. It needs to be stopped immediately. Hold him in contempt, cuff and tase if necessary, and move on with your day.
Then would you, when you're done speaking, would you let me know so that I can ask a question?
I'm not obligated to answer any questions, so I have no intentions of answering any question.
I just really disagree with how the judge is handling this contempt situation. He's clearly in contempt. This is about the 10th time that I would have held him in contempt. He doesn't understand the situation. He's rude. He's obnoxious. He's telling her that he doesn't have obligations to answer questions. He absolutely has obligations to answer questions. He's not here to discuss jurisdiction. He doesn't have a proper motion on that point. And he is here facing criminal charges.
Well, I'll ask it anyway, and you can decide what you want to say.
Thus, where the Judicial Tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term, villain versus villain. Courts enforcing mere statutes, as is to my understanding, that this is a statute, not a constitutional violation of law. In fact, one of the hearings I had with you, you said people are not charged with constitutional violations. I don't understand how you can be enforcing statutes and you have the U.S. flag behind you, as if you had to take an oath to uphold the Constitution. Courts enforcing mere statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. Boswell versus Otis. I've been here 3 or 4 times on the threat of domestic coercion. Prosecution doesn't even have folders in front of him. He has no objections. He has nothing to say. He cannot prove jurisdiction. This court should have been dismissed this case. This is a government court of incompetent jurisdiction. The fact that petitioner was released on a promise to appear before a magistrate for an arraignment, that fact is circumstance to be considered in determining whether the first instance there was a probable cause for the arrest. Monroe versus Poplar. There is no discretion to ignore the lack of jurisdiction. Court must prove on record, all jurisdiction facts related to the jurisdiction asserted. A universal principle, as old as the law, is that proceedings of a court without jurisdiction are a nullity and its judgment then without effect either on personal property. This case has already been put before the federal court, and you will be receiving a notice of removal very shortly. This court has no jurisdiction. Prosecution can't prove jurisdiction. This case shall be dismissed, and it will.
Did you file a notice of removal with the federal court?
Yes, you will be receiving it shortly.
All right. Well, when I receive it, I will rule on it. This is my question to you. Are you employed?
I'm not employed. I'm not employed with any corporations incorporated with the state of New Jersey.
Okay, we get it. You don't have a job.
Are you employed with any corporation that's incorporated outside of the state?
Objection. I'm not here to answer questions about my employment. Last time I was made aware of this was supposed to be about whether this court has jurisdiction, and clearly it doesn't. A question about employment has nothing to do with whether this court has jurisdiction, so I'm not obligated to answer those questions. No, I shall not be answering any more of those questions that are not pertaining to jurisdictional facts.
Well, this is my question to you. I asked it before. If your position is that this court has no jurisdiction to determine its own jurisdiction.
That's the objection, man. That is not my ruling. That is not my holding. I've given you the federal case law regarding such. And maybe you can take some time out that you need to do to recheck that. But that's what the case law says, not what I said.
Well, I do have jurisdiction over you. Number one, you're here in my courtroom.
Objection, man. You do not have jurisdiction over me. I'm here by way of threat, duress, and coercion. The federal case law stipulates already that compelled appearance and arrest warrants doesn't give a minister acting ministerially and not judicially enforcing their statute jurisdiction. That's incorrect and false. You do not have jurisdiction because I'm here. You told me before when I was here that you would lock me up if I didn't come, which was threat, duress, and coercion.
Wow, what a pile of nonsense that was. It's such a pile of nonsense, in fact, that I think I'm going to have to go to the estimated argument again. This time I'm going to have Ollie deliver it for you to summarize all that he just said. Objection. I have no good legal argument, so what I'm going to do is obstruct by objecting constantly, and then I'm going to filibuster until you figure out that you need to hold me in contempt.
I think that you misstate what I told you.
Objection, ma'am. I have not misstated. I have the videos. I have it on repeat, 24/7. I've seen you state.
I don't recall that I said I would lock you up.
Oh, well, objection, ma'am. That's on the record.
Well, you can object all that you want, sir.
No, you can't object all you want, Judge. You're not doing your job. Hold him in contempt.
And I will continue to have a difference of opinion about that. All right. Well, we'll continue with today's proceedings. And I certainly appreciate the courtesy that you extend to me. All right, Mr. Walker, I know that you are here.
Yes.
You wish to be heard, sir?
Your Honor, I have Kevin Walker appearing on behalf of the Office of the Public Defender. We did receive after the last hearing a court order directing the Office of the Public Defender to represent this defendant. Did file a motion for reconsideration, noting that there has been no indigency determination, which is an essential component of our appointment. So I would ask respectfully that an indigency determination be made at this time, and absent that the earlier order directing to represent this defendant be vacated.
All right, thank you.
This poor defense attorney, to his credit, he just wants no part of this whatsoever.
Do you wish to be heard on the issue, Mr. Luciano? All right. I have inquired of Cheyenne Mutada Kushnirel concerning his employment. He tells me he is not employed in the state of New Jersey by any corporation, and therefore I determine that he does not have the present ability to pay for counsel to proceed in this matter.
Objection, ma'am. I don't know this gentleman. I haven't made any contracts with the public defender's office. I don't know what that was an attempt to do, but he is now the authority to speak for me. So I would appreciate it if any non-identified parties determined to act on my behalf. First, fill out IRS 156 and notify the IRS that they're acting in some sort of fiduciary capacity.
This really is fun. We all have to notify the IRS, apparently, when we start a representation. No, you don't.
All right. Let's talk about the issue of, Mr. Walker, I want to talk about the issue of jurisdiction. One of the issues that has been raised in this case and has been raised over and over again, it really needs to be determined before we can proceed with it, is with regard to jurisdiction. I have received, it was filed with the court, it was received in my chambers on January 7th. I'm not exactly sure if it was filed downstairs on a different day. Something that has been entitled a non-negotiable affidavit of fact to dismiss with prejudice for lack of personam jurisdiction, lack of discovery, and lack of an injured party.
A non-negotiable affidavit of fact. We have something for this circumstance. It's called a motion. What you file is called a motion to dismiss, and then state your basis, okay?
It purports to raise the issue before the court of lack of jurisdiction with regard to Cheyenne Mutada Kushner L. Despite what Cheyenne Mutada Kushner L says, this is not an application to the court to dismiss anything with anything. There are certain ways, as you are aware, Mr. Walker, to bring issues before the court. What we need to do is have the issue brought before the court properly by way of a notice of motion. I don't even know if Mr. Luciano got a copy of this, but certainly you know that any motion filed has to be served on the prosecutor. How much time does your office need in order to do that? And did you receive a copy of this?
I have not received a copy of that, and before I address that issue, I would respectfully request that you inquire into this defendant's assets to see whether he has a present ability to retain private counsel.
It doesn't mean he isn't employed by a corporation, so...
Objection.
Oh, this video is just the gift that keeps giving. I love this defense counsel. It says, you know, before I'm forced to try to file some motion out of what this guy said, could you look and see if he has any assets so that he can hire his own attorney? Because I don't want to do it.
This is obscene.
Sir, this is a conversation that I'm having with Mr. Walker, not with you.
He cannot speak for me, man.
Attempt.
Objection. This man cannot speak for me, man. I haven't filled out any public defender's applications nor contracts to agree to that. You cannot force me against my consent to have someone who I have no formal contract or agreement with to speak on my behalf. I'm a natural flesh and blood man. I don't have to have, yes ma'am, I don't have to have an attorney at law, a colorable attorney at law, de facto attorney at law, propose or purport to speak for me in any regards to these matters in hand.
March 23rd, sufficient time, Mr. Walker?
I think so, Judge.
All right. And this matter shall be hereby is continued until Monday, March 23rd at 9 o'clock.
Objection, man. The notice of removal is already in. You will be receiving it today.
If I receive it before March 23rd at 9 a.m., I am aware of my obligations when a matter has been removed to federal court. If for some reason the federal court does not accept it, or it's not properly filed, or there's something else, that's the next stage for this proceeding.
Objection, ma'am. I will not be participating in any more of these proceedings.
Do what you want.
I'm sorry, and I can do that.
This is the only notice that I will give you of the proceeding on March 23rd at 9 o'clock in the morning. We don't send out letters reminding people, simply expect it to be released. Thank you very much.
Be contacted by my office and in the office, and they'll have to sign it.
Do you have his address?
The address I have is the
PO box is right here.
Objection. If you attempt to contact me and negotiate any contracts with me, you will be getting sued in federal court too as well, sir.
All right. Thank you very much.
Well, there you have it. That was an absolute train wreck, and I do blame the judge. And I probably was too hard on her. She seems to be very knowledgeable. She seems to be smart in terms of the law, and her demeanor is fantastic if you're dealing with professionals. But when you have somebody who's in blatant contempt of court, it needs to be addressed, or you're not doing your duty as a judge. And I knock her for that. On the other stuff, she's obviously competent and smart, and you know, nice and everything to a fault. You need to get some backbone and do what you have to do in that circumstance. Here at Law Talk, we do a lot of videos answering common legal questions. We also do reviews of law in the movies and then on TV. We also share some of our more interesting cases. We're always putting out new videos. So if you like that, please hit like, subscribe, and ring the bell.